Hello, this is the Linda Liu IP course. I'm Yu Gao. Today, I would like to share with you some latest information regarding the Chinese Trademark Law. As you know, the newly revised Chinese Trademark Law has been approved by National People's Congress and will officially take effect on January 1st, 2027. What are the core updates, and how should trademark owners prepare for these upcoming changes? Today, I will break down the key revisions for you. For easy understanding, I will summarize the entire amendment with three core words: modernization, efficiency, and actual use. Let's walk through them one by one. First, modernization. More trademark types and valid use forms. Point 1. Motion marks are now registrable. Motion trademarks are officially recognized and acceptable for registration under the new law. This is a huge update for industries where dynamic vision branding is widely used, including high-tech, entertainment, and online retail sectors. Businesses in these fields should start planning their motion trademarks in advance. Point 2. Online trademark use is legally recognized. The new law explicitly defines Internet-based trademark use as valid commercial use, broadening the scenarios for trademark use recognition in digital era. We believe this should be helpful in having online evidence admitted as valid use evidence, as long as online evidentiary documents form a complete chain of evidence to prove the genuine trademark use in China. Secondly, improved trademark registration efficiency. Point 3. Opposition period shortened to 2 months. The opposition period has been shortened from the previous 3 months to just 2 months. This means less time for discovering conflicting trademarks, collecting use evidence, and filing oppositions. For trademark owners, it becomes more critical to cooperate closely with professional trademark agencies for monitoring of potentially conflicting trademarks. Number 4. Narrowed blocking scope of invalid trademarks. Under the current law, a trademark that becomes invalid due to non-renewal, invalidation, or removal can still block new conflicting trademark applications for 1 year after it becomes invalid. The revised law significantly narrows down this rule. The 1-year blocking period only applies to the removed trademarks, excluding expired and invalidated marks, which greatly free up available trademark resources. Thirdly, strict rules on trademark actual use. Point 5. Anti-hoarding regulations. No registration for non-use and excessive applications. This is the most talked about update. The new law rejects trademark applications that are filed without genuine use intent and clearly exceed the applicant's normal business needs. Compared with the old law, Article 4, the new law adds the excessive business needs standard. It clearly distinguishes legitimate defensive filings and filings for reasonable business needs from malicious trademark hoarding and speculative registration. Point 6. Administrative fines for illegal trademark filings. For the first time, the new law introduces administrative penalties for irregular trademark applications. Fines will be imposed on 3 types of illegal acts: filing prohibited signs, applying for trademarks without use intent and beyond business needs, and malicious trademark squatting on others' prior trademarks and prior rights. Point 7. Cross-class protection for unregistered well-known trademarks. This new law extends cross-class protection for unregistered well-known trademarks, making a major progress in China's well-known trademark protection system. It is worth noting that this update does not lower the recognition standard for well-known trademarks. The proof requirement remains strict. Point 8. Ex officio non-use cancellation by authorities. CNIPA is now entitled to initiate ex officio non-use cancellation proceedings to clear idle, unused trademarks and revitalize trademark resources. Meanwhile, the industry has raised reasonable concerns over legitimate defensive trademarks. In practice, we believe authority will exercise discretion cautiously. This mechanism will mainly target long-term idle-hoarded trademarks instead of reasonably reverse-defensive trademarks or marks prepared for future business expansion. Point 9. Penalties for misleading trademark use. In response to the widespread public concerns over misleading and improper use of tricky trademarks in recent years, the new law adds explicit regulatory provisions. It strengthens supervision over misleading use of registered trademarks, allowing any entity or individual to report such violations. Trademark owners must upgrade their trademark compliance management to avoid regulatory risks. Point 10. Licensor's right to terminate the breach of license agreements. This new law empowers trademark licensors to terminate the license agreement if the licensee fails to fulfill the product quality assurance obligations. This better protects trademark brand reputation and clarifies the rights and obligations of both parties in trademark licensing. It is advisable for trademark holders to make detailed agreements with licensees regarding the obligation of quality assurance in license agreements. To make a conclusion, these are the most important updates of the revised Chinese trademark law. If you want to learn more about this topic, stay tuned for updates. Please feel free to contact us for any questions. Thank you.